Mayor.
Okay, everybody, I'm ready to get started. So this is the training. Can we wait for more people? Just go ahead.
I think go ahead.
Yeah.
It's
Okay.
time limit.
Yeah, we gotta get going here.
It's night.
This is the City Council EDA Planning Commission, planning and zoning, training on 3 topics. The open meeting law, government records and data, and conflict of interest. I'm the city attorney, Mike Flaherty. I don't know pretty much anybody other than the council members, but hello, nice to meet you. We're gonna pass out slides, and this is my contact information. So I actually have an office in Winona too, Minnesota, but we have 2 offices. This is our St. Paul office number, and if you call there, they'll get a hold of me.
And then he'll get a hold of me and see if it's okay for him to
Right.
talk to you.
So, call Sunny if you have a question. And so I'm gonna go through these topics. This is a little disclaimer that basically says that, this is general advice. This isn't specific to any situation or circumstance. And that if you have a question on one of these topics, all of these topics are really fact specific. So you're gonna probably need to, I mean, it might be so obvious you understand, but you might need to get more advice about the facts of your specific circumstance. So I plan on this being about 45 minutes. We can do questions then if you want, or you can send questions if you think of questions later to Sunny, and then she'll send them to me and I'll reply to you directly, or I'll just do a Q&A document and send it out to everybody. Happy to take questions if we have time, but the council members have already been here an hour. This will be 2 hours, and some of them have to stay for another half hour, so they might want to take a break, but we'll see. So we'll start with the open meeting law. How many of you are familiar with the open meeting law? Okay. So Adam is the only one who's not familiar. That's okay. Perfectly acceptable. So
Self-explanatory.
yeah, well, it's open meetings that are open to the public. I mean, that's basically what it is, but it gets more complicated than that, of course. Like, it's nuanced and specific, and there's rules and exceptions to rules, just like anything. And so this is the purposes, the requirements and purposes of the open meeting law. The basic requirement is to provide advance notice of meetings to the public. And allow the public to attend and observe the discussion, and if there's a hearing, the testimony. And the purposes are to assure the public's right to be informed. This is not like, it's not like you're on the board of directors of the target corporation. Their meetings aren't public. That's a private corporation. You're on a public body, so the public has a right to know, a limited right to know what you're doing. And the open meeting law sets those limits, and we're going to go through that a bit. And it gives the public the opportunity to observe the decision-making and prohibits secret meetings. So common open meeting law myths. We just talked about this in our prior meeting with the city council, some of this, but must post the regular meetings. That's a myth. You have to do that for special meetings. There's other meetings called special meetings, and we're going to go through that. Must use Robert's Rules of Order. There's no statute that requires any particular rules of order. And we talked about that at the last session with the council, and many cities and planning commissions, EDAs will adopt rules of order, and you have the right to adopt rules of order, but you don't have to. There's no requirement, legal requirement that you do. And that you must allow the public to speak. That's especially true in small towns. Our firm represents a lot of small towns. Orinoco is probably my smallest client, or maybe Rushford's smaller. But you get in those small towns and there's sort of a community attitude more than big cities. And everybody knows everybody, and you want to let people speak, but there is no legal right to speak of the public at a meeting. And you need to remember that it is an organized meeting where you're trying to accomplish things. And it's not a time for the public to say whatever they want. The public will have the right to speak at meetings, but with organization and limited by the rules. And so these are the issues. What is a public body? I'll just fast forward, you are all public bodies. The planning commission, the EDA and the city council are all subject to the open meeting law because you're all public bodies within the meaning of that law. And which bodies are subject to the open meeting law, and then what is a meeting? So the governing body of the city council, school board, and then I didn't put this on this slide, but the state of Minnesota has public bodies too, like MnDOT is a public body. All the state agencies are public bodies and they're subject to the rules too. In fact, more stringent rules. Any committee, subcommittee, board, department, or commission of a public body, examples in Orinoco that I put here were the EDA board, the planning and zoning commission, because you're all here. The city council, standing committees, which I'm not sure you have standing committees here. The Gold Rush Corporation, which is sometimes referred to as a standing committee, is actually a separate corporation, but specifically under the statute that it was organized is subject to the open meeting law. And not private organizations. This comes into play. Examples of this would be like if you have a Legion, like an American Legion or a VFW or an Elks Club, sometimes they'll have a body and people think that's subject to the open meeting law, and it's not. It could be if 3 members of the city council attend the Elks meeting, then that would be a public meeting, but by statute, those are not public bodies. And then there's some ad hoc advisory committees, subcommittees or work groups. And this is the slide that defines public bodies that are not subject to the open meeting law. So if Jim and Jim have a beer at the bar and just talk about city business, that's not a public meeting because there's just 2 of them. There's not a quorum of the council, or any 2 of you that are on the same committee. And similarly, ad hoc advisory committees. So that would be like Sunny establishes, the city administrator establishes a committee to discuss restoration of the baseball field. And this is the summer we're going to restore the baseball field and we're going to fix the fence and do this. And we're just going to set up a short-term ad hoc committee just for that one particular issue to work for Kane, and they're going to meet 2 or 3 times to go through the issues and report back to council. That would not be subject to the open meeting law. And the hallmarks of those are it's less than a quorum. They don't have the power to recommend. They only have the power to recommend. They don't have the power to act. And it's not a standing committee without a regular meeting date and time. An example of that here would be the personnel committee. And then once you'd establish that, but if you have I skipped that one. If you have questions about whether an ad hoc committee is subject to the open meeting law or not, it's always safer to comply with the open meeting law. And that's to provide notice and the public an opportunity to be heard. And if you're not going to do that, you have to make sure there's no quorum, that it's purely advisory, and your meeting only as needed, and you're observing few formalities. There's a lot of gray area with this. So if you want to try and not make something public that is questionable, you want to meet those 4 hallmarks and just understand that if you get challenged, you might not win that challenge because it's not always a bright one. So what is a meeting? And a meeting is any place a quorum or more of a public body discusses public business. And the issues here that we're going to go through here in a minute, shortly, one by one, is whether there is a quorum or not. That can come up. Social gatherings, the Christmas party at Ryland's house. I don't know if you have a Christmas party. You never heard of it, right? No. Yeah, right. And people, the council comes, does that need to be publicly noticed? Communication before or after a meeting. Planning EDA, has a meeting and the meeting adjourns and then there's 5 people and 2 of them leave and 3 of them are there. And can they talk? Sure, they can talk, but at what point does that become a public meeting? An extension, and you've already adjourned the meeting. Joint meetings with other public bodies, that would be like, we do that frequently with EDAs or port authorities in the city. I don't know if I've ever done it with the planning commission, but you could, in theory, have a joint meeting if there was a common issue that you were going to vote on. And then serial meetings, which usually involve electronic communication. So what is a quorum for you? For the city council, it's 3 members. For the planning commission, it's 4 members. And for the EDA, it's 4 members because they're 7-member bodies. And if there's a problem of social gathering, a quorum of a public body attends a banquet, ceremony, Memorial Day celebration, whatever, or a similar event. The best practices are to liberally provide notice for any planned gathering likely to be attended by a quorum. And do not discuss public business at an unnoticed gathering. Example of this is in the city of Winona, every year they do a public improvement bus tour. And so they hire like a charter bus and all the council members, members of the press, whoever wants to drive around town and see what they did that year, like they fixed that, they fixed that. And they notice that as a meeting. And really there's no conversation that goes along and they probably wouldn't do, but they didn't notice that as a meeting to be safe. You know, there could be any number of community events that you might need to notice. And if you don't notice it, you just have to, the reason you're attending this training is if you don't notice it, you should think to yourself, well, we really shouldn't be talking about pending city EDA planning commission, you know, issue with more than 2 people at the same time. Before and after a meeting, a discussion of public business immediately before and after a meeting expands to include a quorum. And I think that's important. So like if there's 5 people around, Dana leaves, Jim Phillips leaves, Jim Richards and the mayor are talking about an issue, that's not necessarily a violation of the open meeting law. You know, but then one other council member, Dana, then kind of meanders over. So you get it, just gotta kind of be careful and use your best, you know, your best common sense. And then serial meetings, this is the one that gets everybody, so I'll spend a little time on it. Kind of a funny, I mean, they kind of made a complicated label for it, serial meetings. But basically that just means meetings one after another. So it's like a game of telephone. Jim tells Jim, this is the issue, I'm gonna vote this way. Jim 1 tells Jim 2. Jim 2 then tells the mayor, Jim 1's gonna vote this way. And here's what he thinks about the issue. You have now engaged in a public meeting that should have been noticed, even though all 3 of them weren't in the same room at the same time. This, I mean, a lot of times I always say that, and I honestly believe this, Orinoco and all my other clients, I think I represent 12 cities. I don't think anybody's intentionally violating the open meeting law. I think that's pretty rare. But I think it's pretty easy to accidentally violate the open meeting law. And this would be one way to accidentally do that. So you should, and there's opinions on this from the data practices office.
That would be for an email in that situation too. wouldn't
Yeah,
it?
could be a telephone, could be a text, is probably the most likely, could be an email. In theory, it could be a Facebook, public or private message on Facebook that multiple quorum, a quantity of that equals a quorum, the members.
If it's on Facebook, it wouldn't necessarily be a private meeting either, it'd be open.
We're gonna have a slide about that. There's a special statute just about social media. But that's why I said public or private message. I think it could be even if it's open because it wasn't noticed, right? Because so they got to provide notice that you were gonna have that Facebook public conversation, which they don't do, so.
And theoretically, actions, believe it or not, residents do watch our meetings, right? And so they could rightly or wrongly interpret some of the voting that goes on and could, if they chose to, through data practices, request information that would cause us to have to produce
Yeah,
documentation that would,
so we'll get to it. I think
perception is,
there's another slide that's kind of on that, and here's the email problem, Jim's question.
Okay.
Public business is discussed, here's the best practices, engage in one-way communication only. Always avoid emails to a forum of the council, and this is, I'm gonna be very well heard on this with everybody. So does everybody know what the BCC function on email is? Blind closed copy or blind carbon copy? So that's what you need to do. So the best practices are, if you're on one of these bodies, Plan Commission, EDA, council, you should not be copying and CCing more than, well, really, you should never be sending a blast email, copying multiple people anyway. Like that brings up other problems in my view, but if you're gonna do that, the best practices are, number one, that it has staff, you have staff distribute it, like Sunny would distribute it, because she's well versed in this, and then she won't screw it up, basically, inadvertently screw it up. And if you're gonna send it to everybody, okay, that's fine. The way I always do it, because I do that, is I send it to the administrator and I CC the mayor, whoever the mayor is in Orinoco, that's Ryland. And then I BCC the rest of the council, and then I usually write something in there, because I always get a text and reply email. Did you send this to the rest of the council? Because you don't see them if they're BCC, but they're, so I'll write a sentence. I have BCC the remainder of the council on this email, so that you know that they all got it, even though they're not listed there. So if you, that's happened a lot, to be honest, and people just don't think about it because like you all, a lot of you are professionals and have jobs and you're copying people all the time on emails. It just doesn't, you don't think of it. So that's what you should do. Just use BCC and have Sunny send, especially if you're attaching information like that should come from a staff person if possible. I can really think of no reason why anybody on any of these bodies should be blast emailing their opinion on an issue to the rest of anybody. Even BCC, that's just not something you should probably be doing.
And if someone accidentally does never, ever reply all.
Yep, and that's the thing, because that's happened a lot. So when I see it, this happens all the time, by the way, all my cities. I haven't seen it in a while, but I'll immediately reply all. And I will say, this is the attorney, please, nobody else reply all. And then as long as you don't reply all, you haven't violated the open meeting law because you're not engaging in discussion, but one reply all will screw it up, so.
I have a question.
Yeah, sure.
Whether it's blind or visible, what makes it not open to the public?
Because
If still if everybody in this room
That's a
was
great question.
blind copied, or everybody in this room was visibly copied, why
Great
is it
question.
closed versus
simple,
not?
it's one simple, you cannot reply all on a BCC. And so you're not having a meeting. The reason you're not having a meeting is there's not a go-between back and forth. The person who sends the email, and the BCC people have no ability to reply all. That's why. But like you say, really, you shouldn't be doing that. Really, it should come from Sunny or Renee or staff. And then it's to avoid that problem. And if you're BCCing everybody or everybody except for the mayor or the EDA board chair, whoever that is, they can't reply all, thus they're not having a discussion, they're not having a meeting. That's why, because you can't reply. It's not, and it's used for information. If you're gonna send information out by email, that's fine. Email is very useful. You can't operate without email. We need email. But it really should be limited to providing information, not engaging in discussion. And that's not, and by BCCing people, you're not having a meeting because you're just providing them information. Attached is a League of Minnesota Cities model policy on conflicts of interest, whatever, So, best practices, I didn't put this in the slide, is you should not be initiating an email to all members of the body. That would be best. If you do, don't reply all. If you have to, BCC everybody.
And I think you've all received an email from me saying, if I'm looking for a response, it's reply to me, do not reply. So, because of this very issue.
So the next one is serial meetings on social media. This is a slide the gentleman, Paul, was bringing up. So they actually adopted a statute in 2014, because for a long time, there wasn't social media, now there's social media. And it's just 2 sentences long, so you guys can go read it, but the essence of it is the use of social media by members of the public body does not violate the open meeting law, so long as the social media is limited to exchanges with all members of the general public. So, for example, commenting on somebody else's photograph or post, and you're not directing it to your co-members on the body, where you take it a step further, and this wouldn't apply, is, you reply to a post, then he's not here, but Scott then replies to your reply. And then Colleen replies to both of those replies right on, even though it's open to the public, you haven't noticed that, and that's then meeting. So you can use social media, but you're right. It's gotta be open to all members of the public and then you're probably okay.
Yeah, so nobody
I
can
would
be
also
blocked.
also add to that, as long as it wasn't a topic that was on discussion
Was.
You just,
amongst the meeting.
you just don't discuss any kind of business.
Right, that's right.
Yeah.
It's common sense. I mean, if you're talking about the Twins game, you're Americans. You have every right to talk about the Twins game. You know, that's not city business. So here's some other open meeting law issues.
Can I ask one question on that, the Facebook one? So what if the site allows people to be blocked that are from the public?
So it's your page,
Yeah, so let's say it's a page I started.
right? It's your private personal Facebook page.
No, it's
Yeah.
open to the public.
Right, but it's
But public
Jim Richards,
is-
like your name at the top and your
No.
picture. Okay.
Well, let's say for instance, citizens of Orinoco. Or if the city has Facebook page.
I see what you're saying.
So if somebody is blocked from that Facebook page, then that's not open to the public. Right?
Well, in the Citizens of Orinoco example, that wasn't the public page, and I don't think it was sponsored by any of the members of the public body. Yeah, so if it's a public page that somebody else starts, let's say some third party, some guy across town here who lives in town that's not on any of these boards, starts that exact same thing, Citizens of Orinoco, and he chooses to block somebody, that doesn't matter. You can
Right.
still engage with that. You have free speech and First Amendment rights. You can still do that. That wouldn't taint it, I think. Having that guy, now it's different. This has come up in a lot of cities. I didn't make a slide about it, but many cities have Facebook pages. And if the city, not in individual members, but just the city in general has, you know, City of Duluth Facebook page. Basically, you can't block anybody, and you can't block anybody and you can't head note.
Yeah, I
Nice
guess.
to see you. Yep.
Thanks.
You can't block anybody and you can't censor anybody because the city sponsored it, but that's not one of the topics we're dealing with.
Mhm.
And so the best advice is. We had a city once, I'm not gonna name the city, but we had a city that was deleting people's comments out that they didn't like. I'm like, you can't be doing that. So many cities don't have those pages anymore. I don't think does Orinoco have one, or if they have them, they don't make them open to the public at all. It's informational blast posting.
Right, it's just open. to
Yeah.
the Public.
And so anybody can comment on it, which is fine, as long as you're not doing what this one city did, deleting people out.
So
Yeah.
we're fine as long as it's not a council member that sponsors that Facebook.
Yeah,
page.
I think once the council, you can have your own personal Jim Richards Facebook page. And if you don't like somebody, you can block.
No, I know, if
Yeah,
it's
that's
not,
fine.
if it's not my own personal
Yeah.
one.
Yeah, well, if it's controlled by somebody who's not a city. Jim Smith down the road, he's not on any of these bodies. He's not on a public body. He can block whoever he wants.
Mhm.
It's not under your control as a council member or any of your council members' control.
Okay.
So, yeah, I mean, this statute doesn't deal with that, but that's just, I'm telling you what the answer to that would be. The statute just deals with your right to use social media, basically. Just gotta be careful about not engaging in a three-way discussion about a city issue on social media, which I think common sense would kick in and you wouldn't do that, to be
Yeah.
perfectly honest with you. Other open meeting law issues is regular, continued, special and emergency meetings. This is a common question everybody asks. Interactive via electronic communication. We discussed it at a meeting 2 meetings ago, the council meeting. So that's similar to Skype, Zoom, WebEx, there's a whole bunch of them now, Microsoft Teams. So long as statutory conditions are met, phone is not allowed. You have to be interactive television. The important things here are, and I didn't make a slide on the actual criteria, but you have to meet criteria to do this. You can't just not tell anybody, then zoom in. That's not allowed. So you have to. I'll just run through them.
I do want you to spend some time on this, because council understands it, but we do have.
Yeah.
Thank you. Thank
So
you.
here are the rules for interactive technology. There's actually two sets of rules. One of them is in a peacetime emergency or pandemic. So if the city has declared an emergency under the pandemic, there's a whole different, or pandemic or other flooding. City of Wabasha just declared an emergency for flooding. The river was flooding and the levee got overflowed. So that's different. If that happens, there's a different set of rules for this. But assuming that those rules don't apply, which they almost never do, I mean, had one pandemic in 100 years. So then there's a different set of rules that are the normal rules. They are this. You can appear by Zoom, technology, interactive technology, television technology, if there's at least one member of the public body present in the chambers, or the city attorney actually, but that won't be me. That'll be one of you. No, thanks. So at least one of you has to be here. You have to publicly notice it as a special meeting, which is important, and this is where it gets important. So there's extra rules with noticing special meetings. And then the location where you're going, where the remote council or EDA planning commission member is going to be located has to be open to the public. So it's meetings are public, so they made this requirement that, you know, if you're gonna be remote, like at your house, let's say, yeah, you're across town and you broke your leg and you just don't wanna come in because you broke your leg. Fine, you can appear by Zoom, but your home address has to be on the meeting notice. And you have to keep your front door open and let anybody come in who wants, which to me presents public safety concerns, but that's just me. That's what the statute says, so, and that has to be in the meeting notice, which has to be published as a special notice. So, a special meeting notice. So that's a long-winded way of saying, yes, you can do it, but there's certain criteria you have to meet. And it's important that Sunny know that so she can do the meeting notice agenda right. Go ahead, Marcia.
If anyone who is gonna zoom in, or is the location that has to be disclosed, the location where the public can attend? So for example,
Right.
one person is here and this is the location where
No.
anybody can attend. Does that mean that all of those people who are gonna look in by Zoom have to have their locations
Yes,
in the notice as well?
yeah, I'll just show you the
What's the
statute.
purpose for that?
And
I don't know. I think they're gonna change, I mean, yeah, it's, I'm gonna show you the statute, because it's actually a pretty straightforward statute. I think it's worth, you know, because people do use this quite a bit.
And notice has to be posted 3 days in advance.
Well, and that makes sense because
Yeah.
because you probably want your public to be able to either Zoom or to come and attend.
Yeah, so.
So that makes sense. But if you've got one public location, it just doesn't seem to me to make a lot of sense that you need to close other locations.
Yeah. I'm with you. So,
Sometimes we don't make the rule.
Yeah.
Sometimes it just happens.
The response to that is when we were to the COVID, I was the chair for Rochester for the appeals board for planning and zoning. And this city person was there and myself. That's the only one they would allow in the building, in the chambers. No one else could, even though it was public, they would not allow anyone else to come into the building.
And that would violate this.
And then, well, I'm just saying is, but they did that, and then they said it was on, then it was put on Zoom. Meeting was done on Zoom.
That was during the pandemic.
That was during the
That's what I was
pandemic. I'm just saying is that they did.
so here's the.
Each location at which a member of the body is present is open and accessible to the public.
So that's, so,
That's goofy.
well, and think about, I'll give you another one. I'll expand how goofy it is. So let's say, I mean, I had a guy that was a snowbird that went to Texas. So you're telling me that nobody in Texas has any interest in the Rushford City Council meeting, like, nobody. But we posted in, I think it was Rushford, and we posted in there, you know, the address where he was gonna be located at in Texas. And I even suggested to him at the time that maybe you should see if you can go to like the public library and use that address, so it's not your house. And then there's that. So then these are the other requirements now that I pulled it up. All votes have to be conducted by roll call, but Sunny would know that and Renee would know that if they're at the meeting. You have to be able to see and hear each other. That's basically it. At least one member, I already told you that. And then there's an exception here for military members or a healthcare exception for medical reasons, but those are rare. I mean, most of the time it's just somebody's out of town. And the other thing with this is that yellow highlighted one is difficult because what if you don't know where you're gonna be located? Like what if you're a traveling whatever salesman or whatever, I don't know. And you know, you go from this city to that city, you're gone for 10 days, you're gonna have to plan ahead. Because she's got to do 3 days notice and it's got to be in the meeting notice. So, yeah, goofy. But there you go. That's the rule. I mean, in the old days, this wasn't allowed at all. So you had to be
almost
here.
discourages it. It's almost worded in a way to discourage the use of.
Well, what I would say is, I agree. I mean, I agree with that. But what I would say is, you know, you should use it when you need it, but you should make it the exception and not the rule, just because of how difficult it is for Sunny to do that. I mean, we don't have a lot of staff here, but I mean, at the same time, it's incredibly useful because it allows people who couldn't otherwise appear and participate and everything, so. You know. Okay. Let's just see. Okay. Why am I? All right, so there you go. Sonny wanted me to go for it. There, went over that. So these are the closed meetings. So there's a whole bunch of statutes. I'm just going to summarize this. We have enough time. 7:04. There's a whole bunch of statutes about closed meetings and open meetings. And you know, you can close a meeting for certain statutory purposes. You can't close a meeting unless there's a statute that says you can close a meeting. And I'll give you some examples. I can't think of really a planning commission example where the planning commission would close a meeting, but EDA, I've got examples.
Yeah.
And council, I've got examples. What?
Like bids, do they ever?
Well, that's, so why would the EDA, why would this planning
Yeah, I
and
don't
zoning
know.
be doing that? EDA does it though. So, this one right here, oops.
For what?
Real estate transaction.
Yep, right here, certain real estate transactions, developer consider offers or counter offers to buy or sell, sell or buy, and review appraisals. And so this has come up a number of times. And like, you know, if you're, let's say the EDA owns property and they're selling property. You don't want to have the opposing party be able to see at an open meeting what you're planning to negotiate, because that defeats the whole, it puts you in a terrible spot to negotiate. So there's public policy behind allowing you to close the meeting for that purpose. And then a review appraisals, that is, I've used that a couple of times when an EDA, Goodview and Wabasha have used it in the last couple of years. Wabasha was developing a bid for their municipal marina. They have a marina at the river. And they were trying to gauge what the value of that was. And they didn't, I mean, that's pretty unique. Like you can't just go to a real estate guy and they'll say, oh, marinas are valued at this. I mean, they had to get an appraisal. So it's very important. And then Goodview had done it with a parcel of property they had bought from MnDOT. So that's when the EDA would most likely use it. The city council, you can just read these.
I can imagine a situation where zoning might encounter this. And that is where you have a request for a variance and the person requesting the variance has a personal protection order that keeps other people from being close by them. So someone who's been assaulted or suffers from domestic violence or something like that. And they might request to close the meeting in order to maintain safety. And that's covered by that situation, that the meeting can be closed for that purpose.
Yeah, if it's an active criminal investigation, now it might, and it's possible, anything is possible, but these are the must be and the maybe. The bottom line is the next slide. So you can look at those. You can look at these at your leisure. But this is what you have to do when you're gonna close a meeting. You've got to provide a specific statutory authority and you must state it on the record. What statutory authority you're using to close the meeting. And you've got to describe the subject matter to be discussed. So our firm has developed this script that Ryland's used in the past. That covers everything you need to do, and I just prepare it. All you have to do is read the underlined words to make sure that you meet the statute. Otherwise, it's so easy to miss something and not do it right, or say too much, say something that's non-public that you didn't want to say. And then you have to record them. Pretty much every closed meeting must be recorded, except once closed under the attorney-client privilege. And that's important. We've had screw-ups with that, because once you've recorded it, then it's government data, and then you got to argue about whether the attorney-client privilege relates or you have to redact it. So you want to make sure you don't, and that's more of a staff. Some of this advice is for the members, some is for the staff. That one's for the staff. And then here's the open meeting law violations and penalties. There's both individual and what I call it institutional, but that would be for the city. And so you can eventually get kicked out, forfeit your public office if you intentionally violate it. You know, there's a reason the league puts this training on, the reason I've done this training many, many times. It's really easy to unintentionally violate the open meeting law. I really think that people try and do the best thing and have good intentions and don't intentionally violate it, but you know, that could come up and you shouldn't do that, I guess, is what I would say. And then this is the second one here. No reversal of official actions taken in violation of the open meeting law. There's exceptions to that. But generally that's the case. Generally that's the case, and bad press and public scrutiny. I mean, you don't want to be violent meeting law. But do your best. You want to do your best to do, I guess.
I can see a lot of instances where a private developer would not want it public that they're interested in certain plots of land or,
That just came up.
I mean,
That just came up. And you know what they did? And then my situation, they wrote a letter. And I was like, why would you write a letter to the city, giving it to a governmental entity, putting it in paper that you want this to be private because they're doing this big business expansion? And I'm like, oh my God. Well, you've sent us that letter. We now possess it. So it is now government data and it is now public.
but isn't that the goal of the EDA is to go seek out developers and say, we've got this land, we've got this opportunity?
And that's a great, so you are,
Counteractive,
you're like 10 steps ahead of the game. So when you do that, you should tell them,
or tell no one here
No.
about my conversations with.
No.
I'm one versus.
but like verbal, so this gets into what is data, and we're about to go through that, but data is not what you say. So you can call a potential developer on the telephone, have a conversation with them, and that's not government data, it's just what you're saying. Once you record it this company did a letter of intent. Well, don't put it in writing, you should just call and have a meeting. And if you explain to them, and you could explain to them, they should have explained to the city in this other situation that they didn't, this is hush hush, and they wanted to, because there's competitors and stuff, business stuff, I don't know. And so in that instance, you could have told them, or the city EDA, Port Authority could have told them, you know what, you shouldn't write anything. The way to handle that is for you to discuss the terms of the, whatever it is, land sale, loan, could be an EDA loan, you're giving them business development loan, forgivable loan, whatever, revolving loan. Have a verbal conversation with them and say, okay, you know, anything you put in paper is going, or an email is going to be government data and it's going to be public. You want that not to be public. The best way to handle this is to have our attorney with the attorney-client privilege draft the draft documents before we put anything in public, you know, in the public domain. And then the first time the public learns about it will be when you're approving the documents. And you know what I mean? And so there'll be a gap of time when the city staff sends the draft documents to you, like 10 days before you vote on it, where if somebody makes a data request, okay, well, then they can maybe get it, maybe.
Well, and the exception covers that, doesn't it? The exception for real estate transactions, if you're talking to a developer and the developer is talking about developing land and you're talking about the value of that land, then that would fall within that exception where a meeting need not be public.
I don't think that's right. I think,
Okay.
no, it's not right. I mean, the The exception to the open meeting law is different than the Data Practices Act. What he's saying is, you know, we don't want this to be public and it applies in both circumstances. So the exception allows the body, the EDA, the city council, the planning commission to discuss their offer for real or personal property. It doesn't say anything about the developer having a back and forth meeting with the body. That's gotta be public. There's no exception for that. So the body can make their meeting private to develop offers or counter offers for real personal property. In theory, you could have them as part of the closed meeting. You could invite the developer into the closed meeting. Yeah, I think that's probably okay to help. You know, that gets a little dicey though, because are you really doing that? Are you really developing offers or counter offers? Are you negotiating with them? And it would depend on the facts, basically. But yeah, they don't want to put anything in writing. Once they put it in writing, it's out there, you know, and the city has to comply with the Data Practices Act.
And
But
obviously,
it's good that you guys are thinking of that stuff though, because that's what you got to think about, you know, how these laws affect the deals you're gonna make or whatever. You know.
and obviously as EDA members, we can't sign an NDA with them to discuss anything.
That's
At
right.
any time.
Yeah, the McDonald's people wanted us to do that once. Can't do it. It's not a valid legal contract, so they don't understand. You know, they didn't get it, so, and we just, you know, a lot of this is just that business privacy stuff is, you know, we know it because we're lawyers that work in this area, but the McDonald's lawyers or whatever, the other corporate lawyers, they don't know. The rules we have to comply with. So it's good that you guys are thinking of that and you might want to tell them, you know, don't write anything down. Let's just have some meetings, just the two of you, be good. And just, you know, meet with them privately and discuss the deal before anything's on paper or before there's an open meeting. And ideally, the first open meeting, when you want to keep something private, the first open public meeting will be where you actually approve the contracts. And before that, there is no meeting. If you do it right, you can accomplish that. So, good though, very good. So I'm gonna whip through this.
So.
Yeah.
Just a quick question.
Yeah.
So if. When you're saying the first meeting approves the contract,
Right. If you want to keep it secret, a lot of times it doesn't matter and the developers are just developing and they don't care if it's secret or not. But if they come to you and say, we don't want anybody to know about this, you can't tell anybody about this. You're in a tough spot because you're a government. You're like, well, the public has a right to know under these laws. And so how do you avoid that? Well, you privately negotiate with them in meetings in your conference room or whatever, not by email. And then you have me draft the contracts for you. And then once I send them to you, then they become public data, but you know, that will all happen shortly before the meeting where they approve them. And so if somebody makes a data request, well, what's the rule on that? You have to reply within a reasonable period of time. So then you know.
So really what I'm hearing is if it's not on paper,
Yeah.
it's not shareable.
And you wouldn't
But
be,
there's-
you wouldn't be meeting with the group, the whole group, you'd be meeting with one or two people.
It's not a quorum, a
Right.
non-quorum.
Right,
Yeah, maybe
so it'd
one of
be,
you and Sunny,
right,
or maybe just Sunny. I mean.
right,
Sunny.
so it'd be like a representative,
Right.
right?
To negotiate, if they want to keep it, but here's what happens in practice. They don't tell you that and they get, you know, and then you don't know. I mean, you're not mind reader here. You don't know that they want this private or many business. Most of the time, that's not the case. And, you know, people are reporting on it. The newspaper's reporting on it. Nobody really cares. If that's an interest to the developer, they need to make that known to you, or you need to ask them, you know, do you care? And sometimes they don't care.
Well, the goal is to not, you know, be public about it. The goal is to gain trust of developers that want to do business in Oronogo.
Or what, you know, could be not even developers. I mean, it could come up in any number of circumstances.
So how does,
Private business owners.
just a quick question, so how does everything we talked about working with city, but we have the developers that need to go to the planning and zoning commission to say, what do I need to do here to get a rezone? So how do you coordinate
Well,
the information to P and Z, EDA? and
that
not keep
doesn't
it-
really
Not
need-
make it public.
well, why would that not be public?
Maybe they don't wanna, they wanna keep it a secret as long as they want to, but yet you need to tell them
Got it.
from a city's perspective,
Well, that's right.
what you can do or can't do.
That's right. So like they're gonna apply for a rezoning and a conditional use permit for some giant manure factory
Right.
that people don't want in the
Yes,
city.
we need those.
It's coming up, but I'm doing a manure factory right now, but they had public meetings with all everybody knows about it, but. Yeah, I mean, in something like that, you just have to know what the rules are, and then. You know, the developers gotta know, or the business, the manure people, they've gotta know what the rules are too, and understand that we can't violate the rules, you know, that's.
In other words, don't assume anything, talk to Sunny.
Exactly. And you know, and if it's something like a $25,000 EDA loan to improve your property. That doesn't need to be, I mean, we don't need to discuss this more than we need to, I mean, that's not a. But the manure factory that we're doing now is, I mean, that's gonna be, it's a huge project and multiple billion dollars, so. This is the kind of the confluence of these two, Open Meeting Law and Data Practices Act. And that's when, what can you discuss? What can you verbally say in terms of non-public, confidential or private data? Like, if you know something private, can you say it at a meeting? And what I would say, we'll go through that here in a minute. So private, non-public data retain their classification, even if it's discussed in a public meeting. So if you reasonably require, next slide. If you reasonably require or need to discuss something, you can discuss it. That doesn't make what's written on a piece of paper public. It still retains its data classification just because you discussed it in public. Here are the sources of the Public Records Act, or the statutes relating to documents and records. The Official Records Act, the Records Retention Statute that requires that you have a records retention schedule on which when you destroy documents and how long you need to keep them. And then the big one is the Minnesota Government Data Practices Act. The official act requires the government entities to make and preserve records and document official activity. The records must be passed on to the successors in office. You cannot, when you lose your election, you can't get pissed and take a document home with you out of City Hall. It's gotta go, you know, it belongs to the city. You gotta, you know, it goes to, I'm just making that up. I mean, I don't think anybody would do that, but what could happen though is documents are sitting in your closet. You don't think of them. You're like, oh, that doesn't belong to me. Records passed on to successors. Records may be stored in any media, not, it should say, in any media, not just paper, I should say medium. The records retentions, statute, I'm just gonna say you need to establish a records retention schedule. Sonny and I are working on that. So the Government Data Practices Act, the general rule is you presume all data is public, accessible to the public. The purpose is to protect the rights of data subjects. It requires the government entities to establish policies and procedures to give the public appropriate access. You're required to have a data practices policy as well. Records retention schedule, you gotta have a data practices policy. And then, so government data means all data collected, created, received, maintained, or disseminated by any governmental entity, regardless of its physical form, storage, media, or condition of use. That's just things you can physically touch, like a zip drive, a CD that has government data on it, anything of any form. The video of this meeting that Renee is recording, that's government data. Where is government data? Anywhere it's kept. City-owned equipment, including, and it can be in personal email accounts stored on personal computers. You don't want to be doing that. So does the Planning Commission and the EDA each get a private email? Like a city, does the city assign them an email?
Not yet.
Okay, so you probably want to at least consider trying to do that. It's not too expensive. So if you don't, anything you have in your private Gmail account, let's say, is public, is data. It's government data. Just because it's on your private email account, there's a opinion on that. There's a data practices opinion on that. And so what cities have done is issued people laptops in your own private email account, and you should just use that private email account for city business, your private email account for private business. Otherwise, we get a data request, you're gonna end up having lawyer Mike sift through your private emails which can get awkward, you know, we don't want to do that. So, classification of data, and this is, I'm just gonna quickly go through this, we're losing time, but data on individuals, data not on individuals, basically that's public data made. Public data means available to anyone for any reason. Private or non-public data is only available to the data subject. So like, for example, if it's a police report about you, you called the police arrived at your house, gave you services. That document, that police report's a data about you, so you get access to it. But it's an entity, individuals like lawyers and other people who reasonably require access can get it. Or people authorized specifically by law to get it, but not everybody. Confidential or protected non-public is available to the entity individuals who require access, but it's not even available to data subjects. So in this, one of the things I do is I'm a prosecutor, criminal prosecutor, and I've done the data practices for multiple cities for a number of years, law enforcement data, and this gets complicated, but generally speaking, if you have confidential data, you can't even give it to the data subject. There's exceptions to everything, though. Access to data, the city must maintain data so it's readily accessible. That was a hard thing for small cities when you've got not a lot of staff and not a lot of technology and you got file cabinets and this and that, but and you must allow inspection and copying of public data. There's no requirement to create data that does not otherwise exist. That's the common data practices request where somebody from the public says a data request that says, explain to me why the city did this. Well, what they're asking you to do is write an explanation. You're not required to write an explanation. It should say, that request should be made this way. Provide me data on all, in any physical form related to topic X. And then you have to reply with what you already have. You're not required to create what doesn't already exist. And this is the questions to evaluate. Is the request for data or a question like I just described? Is the request for government data, or are they not even requesting data that the government would have or is classified as government data? Is it clear and understandable? You can deny data requests that are not clear and understandable, or you can't reasonably comply with because you don't know what they're asking. Was the request made to the correct person? For the city of Orinoco, that's Sunny. Other cities have different, what are called responsible authorities of different sub-departments like police chief, fire chief, but you guys don't have that. Is the requester the subject of the data? That's the threshold question, because that triggers different timelines on your request. If they're the subject of the data, you got to do it within 10 days, otherwise just a reasonable period of time. And are they requesting to inspect the data or just to get actual copies of the data? And this is kind of, I'm just trying to go really quick. This is a lot to digest, but must allow inspection of data or provide copies as soon as reasonably possible if it's a member of the public, 10 days if it's a data subject. And this kind of summarizes the rules I just went through. You have the slides, you can go through the questions. And then if the data is classified as public, provide data, data subject, provide data. If the data is classified as non-public or private, the public requester do not provide data, but the law requires you specifically to state legal authority as to what makes the data non-public. If they are a data subject, you provide it. And if it's classified as protected, non-public or confidential, you don't provide it. The Tennyson warning, that's when people fill out a form to submit something to City Hall. A lot of times there'll be a Tennyson warning on that basically warns them the information that they're putting on that form could be public and accessed by other people. Informed consent, that's when a third party requests data on your behalf. Jamie gets in a car crash and you don't have a police force here, but they make a request for the police, your lawyer makes a request for the crash reports. But your lawyer makes the request. So your lawyer has to get you to sign a form saying your lawyer can have access to what would otherwise not be public. This is the fees. This is more for city staff, so I'm just going to skip over it, but Yeah, you can't always charge. You can sometimes charge. Members of the bodies don't really deal with this. It's more staff that have to deal with this. And one thing I will say is we need to make sure you have a data practices policy that mirrors what's in statute here so that, because otherwise you're gonna break the law. Oops. Back. So these are examples. Oops, I did it again. These are examples of non-public data, social security numbers, attorney-client privilege data, law enforcement data. Just examples. There's infinite. I mean, it's an incredibly complex and broad area of law, but these are kind of some of the main ones. And I would say the labor relations information is one that comes up a lot. So if you're going to do a labor investigation, that would be applied there. And then employee data on employees is presumed private with the exception of that are listed in that statute. So the bottom line is, yeah, I'll get to the bottom line at the end here. So, but then there's certain basic information that's public. So it's all private with the exception of what's in the statute, and that's mostly basic information. The name, the job title, salary, value of the nature of the benefits, data of first and last employment, et cetera. Applicant data. These are people that apply for jobs for the city but aren't hired. And this is what's public and private in those, in that class of data. And then violations, this is what I wanted to get to. So you could be charged the actual damages resulting from the violation, which could get onerous. If you provide information that you should not have provided that's defamatory towards somebody, you don't want to be doing that. So, and then there's exemplary damages in statute. And then if you willfully violate it, so this is for all of you. If any of you get a piece of data and you deliberately go down to the Tilly's and give it to everybody and it's not public, that's like a willful violation. You don't want to be doing that. And so now we're at conflicts of interest. I can just skip it or we can do it in 5 minutes. What do you think, Sunny?
Go for it.
Go for it. All right. So I'm just going to skip to the most important part. We don't have a code of conduct. I looked.
Yes.
Yeah,
Don't have one yet.
you can have a code of conduct. Many cities do, and they'll just have like a statement about what you should and shouldn't do to help direct you. There's 2 types of conflicts: contractual conflicts and non-contractual conflicts. So the general rule is this. This comes up in EDA a lot. And it can come up in the planning commission, although planning commission doesn't really make contracts. They more recommend contracts that the city makes. EDA is a body politic and corporate. It's not a committee of the council. It's actually its own corporation, and you can actually make contracts in your own name. And be sued is it's in your enabling resolution. So you cannot enter into a contract with a counselor that has a personal financial interest. And this comes up more than frequently than you think. And then there's a whole bunch of exceptions to this. And you can read about those there. And you can't, so a lot of people think, oh, we're on a 7-member board. This guy is applying for an EDA loan. He's on the EDA. He'll just abstain and we can grant his contract. And that's not right. For contracts, you cannot enter into an illegal contract. That would be struck down as null and void in court if you enter into a contract with a contractual conflict of interest. So that's the difference between non-contractual conflicts, where you can solve the problem by just abstaining from voting. What is a financial interest? This gets into the nitty-gritty. A lot of times in small towns, it's more basic than this. It's not, membership in a pension plan, but those are examples. And so the non-contractual conflicts is the more wishy-washy gray area. So you're not entering into a contract with an interested official, but that, you're sitting on a board or a body. And, a decision comes before you and it's not entering into a contract. So it's not categorically illegal without an exception, we make it categorically illegal, but you are so interested in the outcome of this that it's a conflict. That's what, and that's pretty great. And here are the factors to balance. Are there other protections or review procedures, or is it your vote necessary for this to go forward? The need for officials to participate, the number of interested officials, the nature of the financial interest, the nature of the decision. These are from a court case, appellate case, a Supreme Court case, and they've laid out the factors. Now the league just advises on this. So, I mean, this could come up in any one of the bodies, the city council, the EDA, or the planning commission. That talked a lot about the EDA, the planning commission. If your next door neighbor is applying for a variance that's going to affect your property, you probably can't be so independent that it wouldn't be a conflict. At that point, you should abstain from voting on that issue. It would be that's like a simple example. There's a gift ban. So wish we had more time for this. A gift is anything of value given and received without the giver receiving something of value. And the general rule is local officials may not receive a gift from any quote interested persons. This can get complicated, but that's the general rule. Yeah, so don't accept any Mercedes as gifts. That would be no good. So contractual conflicts, here's how to resolve. This is the most important. Yeah. Okay, this is the most important slide. I'm just gonna end it after this. So how do you resolve the conflicts? Contractual conflicts. You may not enter into a contract with an interested official unless there's an enumerated statutory exception, which there are many. And EDA, this comes up if you have a banker. Do you have a banker on the EDA? Negative? Okay, that helps. So a lot of times local communities will have a person that's like the loan officer at a bank sit on the EDA board, but there's an exception for that. Okay, there's a whole bunch of exceptions, then you can do it. If it's not a contractual situation, here's the best, and Orinoco's kind of been doing this wrong for a while, so I've been meaning to do this. We haven't had one in a long time, but in the way early days, many years ago, there was multiple different members were doing something called standing down. I didn't get that, but here's what the rules are. If you have a conflict of interest, you should disclose the conflict of interest to the meeting chair, which is Ryland EDA board. You should have a chair. Planning commission, you're the chair, Wendy, right? Yeah, so you would be the person. You disclose it to that person in writing, then you state the conflict on the record at the meeting, and then you abstain from voting and participating in decision-making of the body. And then kind of an advisory from the league is you could leave the whole chambers if they're going to decide it. The idea being if you're there, people will stab you in the back, they won't stab you in the front. So if you're right there, you might influence them just by you being there because they don't want to tell you no to your face. Yeah, that's optional. You don't have to do that. It kind of depends on the circumstance. I mean, a lot of times when there's conflicts and somebody abstains, it's like a 5-0 vote or 4-0 vote. You know, they abstain and it's unanimous and it's just no big deal. Sometimes it's highly contentious and you kind of have to figure it out. So, and then participating in the decision-making, if you think you can just abstain, but then you can go lobby all the members of the body and coerce them into doing what you want. You can't do that. So, okay, I went 5 minutes over, but there was questions. I took questions. It wasn't my fault.
Right, and I have a question. So on the, if they're abstaining, okay, they do have to state the reason why.
No, they
No.
could just state.
If they vote nay, do they have to?
Well, they can't vote at all if they're going to declare a conflict.
Oh, absent the conflict of interest.
Oh.
I'm just saying in general, in taking a vote on a matter. Is it appropriate if you're voting in the negative or abstaining to state why?
I've never seen it not done that way, but I don't think there's any reason you'd have to state what the
So
conflict
it's not
is.
statutory. or
Yeah.
anything.
I mean, people generally just say, well, you're granting a variance to my sister's business. She's running a beauty salon in her basement. I'm just gonna abstain. It's my sister's business. And then they pass it on a unanimous vote and then that's the end of it. That's the most common, you know.
Is there a difference between a regular motion and a resolution? Abstaining on a resolution.
Well, there's no difference for what the member has to do, but the staff then would have to write that on, because usually there's a roll call on the resolution, they'd have to write abstain.
Same, thanks.
So, you guys had a lot of good questions, particularly DDA members. That was, impressive questions. So if anybody wants follow-up on any of that, just email me or email Sunny and I'll follow up. I was going through it really fast, but the questions were good, so it was worth it, I think. Thanks.
Thank you, Mike.
Thanks, Mike.
Thanks, Mike.